Good morning. Welcome to another installment of Environmental Essentials for In-House Counsel. I'm Brittany Pemberton, a partner in Bracewell's Washington, D.C. office, and I'm joined this morning by my colleague Daniel Pope, who resides in our Austin office. So we're talking today about the Supreme Court's opinion in Loper Bright Enterprises v. Raymundo, which overruled the important administrative law case Chevron versus NRDC. As you may have seen, a number of Bracewell attorneys, including lawyers in our Environment, Lands, and Resources group, have commented extensively already on Loper Bright. But since a lot of that was in the early days after the opinion issued, we thought today we'd try a slightly different approach. Rather than spend a bunch of time walking you through what Chevron deference was and why it mattered, we thought we would just highlight that history for you quickly and then focus most of our time today on how Loper Bright is impacting statutory interpretation in the courts so far and what all of this is going to mean for agency deference going forward. Daniel, do you want to quickly walk us through the background?
Sure, Brittany. I'll try to be as swift as possible. It's hard to talk about Loper Bright and the demise of Chevron deference without talking a little bit about Chevron deference. We're all familiar with this doctrine, although it's no longer applicable to questions of statutory interpretation as understood by federal agencies. It's worth going over the classic two-step. Under Chevron deference, when courts are faced with a question about whether an agency acted lawfully under its organic or action statute, the first question is always, is the text at issue in the statute vague or ambiguous? If the statute is clear, the Supreme Court's always been insistent that that's the end of the matter. Congress spoke clearly. There's no need for agency deference. But on the other hand, if the statute is vague, or capable of multiple meanings, then the court would look at whether the agency offered up a plausible, permissible, reasonable reading of the statute whenever it took an agency action. Over time, that two-step became what Chief Justice Roberts called in the Loper Bright decision a dizzying breakdance. We even got Chevron step 0 and a number of other doctrines, and you really had to have a map of how Chevron deference applied to address questions of administrative law. Now, when it was originally decided, Chevron didn't appear to be this massive administrative law landmark. Certainly nobody thought that it was going to become the most cited administrative case in United States legal history. It instead was a pretty simple case about what the word source means under the Clean Air Act. And following the court's decision in Chevron versus Natural Resources Defense Council, the Supreme Court didn't really rely on the concept of Chevron deference all that frequently. That changed, however, in the late 1980s when the D.C. Circuit Court of Appeals began to use Chevron to manage its extensive administrative docket. And an early advocate for using the decision as a deference canon was then D.C. Circuit Judge Antonin Scalia, who would later, of course, become Justice Scalia and a critic of Chevron deference. Justice Scalia's rationale in the late 80s, and he talked about this in law review articles and in other presentations, was that Chevron is actually kind of gets courts back sort of in the terrain of interpreting the statute. Before Chevron deference, before the 1980s, courts would look to legislative history frequently. What did Senator Muskie say about this particular provision of an environmental statute? Then Judge Scalia believed that Chevron refocused the court on the statute itself and less on legislative history. But over time, Chevron became one of the most cited administrative law cases, as we mentioned, and it became deployed increasingly frequently. And when it became deployed more frequently, it became more controversial. Litigants who believed that they had arrived at the best reading of a statute might be disappointed to go to court and find that Chevron deference was the basis for overriding their interpretation of the statute. Agencies also increasingly relied on the presence of Chevron deference in the sort of constellation of administrative law decisions, and they began to expand their policy role, sometimes beyond their statutory limitations. So eventually, litigants began to challenge Chevron deference itself, and we've seen this in other administrative law cases where other deference concepts have been challenged. We saw a few years ago Kaiser versus Wilkie over the concept of hour deference, which we'll touch on a little bit later today. And then judges themselves became critics, and then in the case of Justice Gorsuch, a Supreme Court justice himself. So much for Chevron. I want to talk a little bit about the background of the Loper Bright case itself, and then I'll kick it over to Brittany to talk a little bit more about the decision. In Loper Bright Enterprises and in its companion case, Relentless, Atlantic herring fishermen challenged this rule that had been promulgated by the National Marine Fisheries Service and the Department of Commerce, which required fishermen to pay for third-party government-approved observers who would travel with the fishermen on their vessels and supervise them, count the number of fish caught, and so on and so forth. And the Magnuson-Stevens Act does authorize NIMPs to require some vessel owners to pay for observers in certain circumstances, but there were 3 provisions that allowed NIMPs to require vessel owners to pay for observers. None of them clearly applied to the rule at issue for the Atlantic herring fishery. Atlantic herring fishermen challenged these rules, and initially courts reviewing the rules relied on Chevron deference to uphold the rule. One treated the absence of statutory authority as an ambiguity itself. Another court concluded that the rule was within NIMP's statutory authority, but didn't describe which Chevron step was the basis for upholding the rule. So the Atlantic herring fishermen sought cert, and their petitions were granted.
So as you may already know, the decision was split along ideological lines, and you can see that in sort of the shuffling lineup here of the photos of the justices. The Chief Justice wrote the majority opinion. A couple of other justices wrote their own concurrences, and then Justice Elena Kagan authored the dissent for a whopper total of 114 pages of opinion. The opinion itself is pretty simple. Loper Bright held that Chevron is overruled. No ifs, ands, or buts about that. Very clear. It did so based on the principle that it's judges who say what the law is, both from a constitutional perspective and under the Administrative Procedure Act. The opinion really heavily relied on rationale under the APA as opposed to that Article 3 rationale, but it does mention the other one. And now what we're left with is that courts are to use all tools of statutory interpretation to determine what the best reading of the statute is. And that applies even in situations as our slide notes where what is the best reading may not necessarily be 100% what Congress intended. Courts get to say what the best reading is, and if it's not the best, then it's not permissible. So what are the tools of statutory interpretation? We could do an entire 30-minute webinar on just those, and I'm sure you're familiar with a lot of them. Lots of folks start with the dictionary definition. Obviously, there are different canons of construction and interpretation, but one tool that definitely needs to be mentioned whenever we talk about Loper Bright is this tool of due respect, which really comes from the Skidmore versus Swift and Company opinion, which goes all the way back to 1944 from the Supreme Court. And it's the Supreme Court's pre-Chevron approach to agency deference issues. In that opinion, the court instructed lower courts to consider the thoroughness, reasoning, and consistency of an agency's view and all of the factors that give that agency's view the power to persuade, even if they lack the power to control. So what courts can do going forward is take into account the agency's view, but those views don't control or excuse the court from arriving at the best interpretation of the statute itself. What the agency thinks the statute means is important, but it's not outcome determinative like it would have been in certain cases under Chevron. The Supreme Court recognized that there will still be situations where the statute commits a decision or an action to the agency's discretion. And the other thing we can learn from Loper that I think is important here is that the court says that reviewing courts are to be sure that the delegation falls within constitutional limits and the outer boundaries of the statute. And then their job, if they check those boxes off, is to make sure that whatever the agency has done is actually reasoned decision-making. So Daniel and I are each going to walk through a couple of recent examples showing how Loper Bright is being applied. His are in sort of a broader context, and then mine are more environmental law focused.
Thanks, Brittany. It's only been a couple of months since we started reading and writing about Loper Bright, and less than 3 months after the decision, it's already having an impact on some pretty significant cases. One of the first decisions handed down by any court where the court used Loper Bright or followed the instructions of Loper Bright to strike down a pretty significant bit of administrative rulemaking was in Ryan LLC versus the Federal Trade Commission. This is a case coming out of the Northern District of Texas in Dallas. The FTC, you may recall, had issued a rule that banned the use of non-compete clauses in employment contracts. Those are always somewhat controversial, but the FTC viewed them not just as controversial, not just as a matter between an employer and an employee and what the labor market would tolerate, but rather a basic element of unfair competitive practice. So they banned the use of these clauses. Ryan LLC and the United States Chamber of Commerce challenged the rule banning non-compete clauses, and it argued that while the FTC is authorized under the FTC Act to prevent companies from engaging in unfair methods of competition, the FTC is required to check those unfair methods of competition through case-by-case administrative adjudication, basically trials before the agency itself. There are rules, and the FTC pointed out that there are provisions in its statute that give it rulemaking authority. So the question was, well, what's the scope of that rulemaking authority? The FTC said, we have the power to make rules. The challengers said, no. You can make rules insofar as those rules relate to the procedures before the FTC in these case-by-case adjudications of unfair methods of competition. The Northern District of Texas District Court, following the Supreme Court's instructions in Loper Bright, identified the best meaning of the FTC Act and found that its rulemaking authority really was limited to the procedural elements of that case-by-case adjudication process. And as Brittany was pointing out, there are so many different ways of interpreting a statute. What the court was doing here, which I think is significant, is it was looking not just to the text, but to the overall structure of the FTC Act. And I think that we're going to see more and more discussion about the structure of various statutes and how the structure of those statutes informs the meaning of a particular grant of authority or particular instruction from Congress. So following that, the district court vacated the non-compete rule. Just a few days ago, you may have also seen that a rule from the Department of Labor was struck down. This is a tip rule that the Department of Labor promulgated under the authority of the Fair Labor Standards Act. Some of our listeners may have had previous jobs as waiters in restaurants. You may be very familiar with the ability of restaurants to pay their employees less than minimum wage if that employee is considered a tipped employee. And the Fair Labor Standards Act defines tipped employees as those engaged in an occupation in which the employee customarily and regularly receives more than $30 a month in tips. So the Department of Labor recently finalized as a rule a longstanding position it had taken in guidance documents that tipped employees spend at least 80% of their time doing work for which they receive tips, like serving patrons, serving food, not rolling silverware, not mopping the kitchen and that sort of thing. And the district courts upheld the tip rule on Chevron grounds, but the Fifth Circuit reversed and vacated the rule on the grounds that the 80-20 approach to how tipped employees spend their time violated the clear line drawing of the statutory text of the FLSA, which again, tipped employee is any employee engaged in an occupation in which he receives $30 a month or more in tips. So the Department of Labor erred in focusing on that sort of proportionate type of activities approach and not the statutory definition of the tipped employee in the text. And the Fifth Circuit, of course, didn't give an opinion on whether the DOL's approach was good policy or not. It just said that there's a clear provision of the statutory text that addresses this issue, and the Department of Labor is not authorized to deviate from Congress's definition. So even though, and going to our discussion of Skidmore deference and the ability of longstanding agency positions to inform courts, the Fifth Circuit looked at the longstanding Department of Labor guidance, which had been in place since the late 80s, and concluded that this makes sense as a policy, but it doesn't have the power to control. The statutory text has the power to control. So I think this is a good example of how clear meaning in a statutory provision is enough to carry the day under Loper Bright. Brittany, talk to us about how we're seeing Loper Bright cited, deployed in some environmental cases that you've been tracking.
Sure. So I wanted to highlight a very recent example. This just came out within a matter of days ago out of the DC Circuit. This is the U.S. Sugar Corporation versus EPA case. It may be the first, if not one of the earliest DC Circuit opinions involving statutory interpretation in EPA rules under Loper Bright. The parties in this case mention or cite to Chevron in their briefs, but only at a very high level. EPA did not argue this case in a way that it necessitated Chevron deference. It just sort of noted that it had the best interpretation of the statute and that even if Chevron applied, it would still win under that as a fallback. But what I think is really notable about this case is that it's a good example of a situation where EPA may have actually won under Chevron, but didn't do so under Loper Bright. There are two main statutory interpretation issues in the case. Just in the interest of time, I'll just focus on one of them. But the court really ended up looking, as Daniel was just nicely highlighting, and I promise we didn't actually plan that, but it was a good segue. The court ended up highlighting really statutory structure and context in figuring out what the best interpretation of the statute is. And it also inserted, I think, a fair dose of common sense into choosing the best interpretation. So just to walk you through one of the issues, in Section 112 of the Clean Air Act, a new source is one that is built after EPA first proposes regulations under this section establishing an emission standard. EPA read that language as authorizing it to call boilers, which is, as you can see from the slide, the subject of this rule, new for purposes of regulations that it was issuing in 2022, if the boiler was built after it was first proposed under an original rule going all the way back to 2010. Industry interpreted this statute, as EPA had in many other similar rules, to mean that an emission standard is first proposed when EPA first proposes each consecutive standard. So here, that would mean that the only new boilers would be those built after 2020 when EPA proposed the revised standard. The court noted that the statute's language about first proposing standards read in a vacuum could be interpreted either way, but it sided with industry on this issue because the statute's structure and context persuaded it that that was the best interpretation. Why I think this is interesting is that if you look at the makeup of the court on this, it was a per curiam decision issued by Judge Katsas, Judge Wilkins, and Judge Walker. Two of the three of those judges were appointed by President Donald Trump, and the other was appointed by President Barack Obama. One often assumes when dealing with the DC Circuit that democratically appointed judges tend to have at least a slight lean towards EPA in cases like this. But the three of them agreed that there was a single best reading of the statute on this particular issue. And if you got a different panel, I think there's a decent chance, the court having noted that really when emission standard is first proposed based on the plain language of the statute could be read more than one way. I think there's a good chance that if we had been under a Chevron regime here where EPA said this is our interpretation, the statute is subject to more than one reading, and we get deference, I think this really could have turned out a different way. And it's a very meaningful victory for the industry folks that were fighting against this new boiler definition, as many of under Section 112 of the Clean Air Act, new sources under hazardous air pollutant regulations get the most stringent standards. And so this was their best attempt at avoiding some more stringent standards that came out as a result of this rule. And now everything that EPA was saying was new isn't necessarily new anymore. There's a second issue in the case, which is highlighted a bit on the slide, that the court noted was really a tricky question. But interestingly enough, when they weighed the competing views of the statutory interpretation, the panel took the view that the environmental petitioners that espoused this interpretation of what data EPA can look to in doing risk and technology reviews under Section 112 of the Clean Air Act, that the environmental petitioners' view just cannot possibly be correct. So the other case that I thought I'd mention this morning is actually not a Loper Bright case, but it is a very recent DC Circuit case that I think is worth highlighting because it shows where there is an open issue, I think, left in light of the demise of Chevron. And that is really the question of what deference is owed to an agency on technical, scientific, or policy issues. So this is a case that involves the chemical industry's challenge to more EPA Section 112 of the Clean Air Act emissions standards. There's a lot going on in that area, as I'm sure many of you know. These particular emission standards deal with ethylene oxide emissions. The chemical industry brought arguments about the validity of EPA's cancer risk assessment, which is a big part of how EPA sets the standards under the risk and technology review. They challenged EPA's process and they raised constitutional concerns. The D.C. Circuit ruled against industry on every single one of these issues. In addressing these arguments on the validity of the cancer risk assessment, the court sided with EPA under what D.C. Circuit often calls an extreme deference standard. This isn't new, and it's something that other courts have used, but it's been quite prevalent in the D.C. Circuit, just depending upon the situation. So while deferring to the agency on scientific or technical issues may seem like a way to have the best of both worlds post-Chevron, closer judicial scrutiny on what a statute means, but reliance on an agency's scientific or technical expertise. This is a good example of the ways that this can be problematic because it really allows the agency and the court, if they're game, the opportunity to characterize issues as purely technical when they really don't necessarily have to be read that way. For example, in a rule like this, the Clean Air Act tasks EPA with assessing whether emissions of hazardous air pollutants pose a residual risk. For carcinogens, that involves identifying the level of exposure that causes a 1 in 1 million cancer risk. Where EPA finds that risk unacceptable, then it revises these existing hazardous air pollutant standards. Here, EPA relied exclusively in undertaking this process on its own integrated risk information system, or IRIS value for ethylene oxide, and it only used other risk evidence in the record for the very narrow purpose of figuring out whether that evidence was sufficient to drive EPA to reassess the IRIS value. So if it wasn't persuaded by a study that industry submitted or other scientific evidence that was in the record that it needed to redo the IRIS value, then it just pretty much ignored that scientific evidence. Industry argued that what evidence EPA needs to look at in identifying the cancer risk in order to figure out whether there's residual risk that requires the standard to be revised is a legal issue. What in the statute allows EPA to prefer its own IRIS values over other scientific studies or data regarding the cancer risk of ethylene oxide, the pollutant that was at issue? But EPA and the court were able to really sidestep any statutory interpretation by construing all of this as the type of issue that's technical and scientific in nature and subject to the agency's expertise. So you can see when these cases of potentially extreme deference come up that the way the issue can be framed may be a way to actually avoid Loper Bright, and the court completely does that here. There's no hint of statutory interpretation or that there is anything other than sort of an arbitrary and capricious review going on when it comes to all of the various arguments that industry brought to try to challenge the standard.
Brittany, I think that point about framing is really crucial. How you frame a particular legal question as a legal question or as a policy question or as a straight up fact question is going to be really important as we move into this new era of agency deference. So where are we? When it comes to statutory interpretation after Loper Bright, Chevron's gone. Courts are going to have to use the tools of statutory construction to identify and apply the best reading of a statute to a question about an agency action before it. Under Skidmore, courts can respect long-held agency positions on these questions. Those agency positions can be really informative, but those long-held positions are only persuasive. They are not controlling, and courts will be the ones making the judgments about whether they're going to agree with an agency's reading of a statute as the best reading, right? They're going to make that conclusion independently of long-held agency policy, or they're going to overrule an agency action and disagree with an agency's interpretation, even if it's been around for a long time, as we saw with the tipped employee rule from the Department of Labor and the guidance that informed that rule. Statutes can commit actions to agency discretion, as Brittany talked about. And Loper Bright affirms that. Courts must confirm, though, that the delegation from Congress to the agency, from the legislative branch to the executive branch, falls within constitutional limits. So we're thinking about separation of powers. We're thinking about the non-delegation doctrine and the requirement that there be an intelligible principle for that delegation. And courts, when they're reviewing a commitment to an agent, the commitment of an action to agency discretion, they've got to ensure that the agencies are not straying beyond the statute's boundaries. And so that's a text question, or acting unreasonably. One thing that's kind of interesting, and we already mentioned Kaiser versus Wilkie upholding the concept of our deference. That is the deference a court might show to an agency's interpretation of its own regulations when they're ambiguous. Loper Bright doesn't disturb that. It's going to be interesting to see if petitioners will try to revisit that after Loper Bright. And then when it comes to factual analysis, when it comes to technical and scientific issues, when it comes to an agency's policy choices, the courts are going to continue to defer, or in the words of the DC Circuit, to extremely defer to agencies like EPA.
Daniel, thanks so much for sort of rounding up all of the takeaways from today. I think these, aside from maybe the high-level statutory interpretation bullets, really give a good sense of where there are open issues still. And I think a lot of this just remains to be seen as it works its way through the lower courts, district courts in some instances, or the DC Circuit and other circuit courts, if you're dealing with something like the Clean Air Act, on the question of the statute committing an action to agency discretion. We just need to see that play out in action when there's a challenge to an agency decision or a rule where something is left to the judgment of the administrator, or requires the agency to make a determination that something's plausible or that something a state has done is adequate. How those terms will be read and how the interplay between the separation of powers and other constitutional limits will come into play, I think, will depend on the issue, and it's going to depend on the court. And it will take a while for those sort of things to come to a head. If they do, I think the same could be said about the other issues, especially our deference and the extreme deference issue. Since we have been on a bit of a trend with the Supreme Court in recent years, there's a sense that the court has been taking steps to narrow agency authority. You could see where both of those issues may be something that the Supreme Court would be interested in if the right case comes along to try to take up what the scope of our deference is, and should agencies actually be able to just leave ambiguities in their own regulations that they can then exploit to their own advantage, or sometimes to industry's advantage when it comes to implementation. And how does this extreme deference doctrine fit into what the Supreme Court has been envisioning as the proper role for agencies in our constitutional structure? Well, I think that takes us to the end of our 30 minutes this morning. We appreciate everybody taking the time to tune in. We hope that this has been interesting for you all. As always, please feel free to reach out to either one of us or really to anyone that you have a good relationship with at Bracewell and our Environment, Lands, and Resources team if you have any questions about the end of Chevron deference, about how any of this would work in a particular situation under a particular statute or in a specific rule that you're dealing with. We are always glad to chat and to do our best to answer your questions. And lastly, just wanted to make a plug for our upcoming environmental law seminar. That's our half-day event that we typically host in Houston live and have a live stream component to as well. That is going to be in November on November 13th. We appreciate you all tuning in.